And specifically, this is a show cause hearing directed to Ms. Bruni, for Ms. Bruni to appear and show cause why she did not participate in the pretrial order. And I see that Ms. Bruni was not represented by counsel, correct?
That's correct.
Okay. Then the court will allow you to take the podium and give argument. If you would like to take the stand and testify, you may do that as well, and you'll be subject to cross-examination at that point. Please take the podium.
I was found aware that I was supposed to prepare a pretrial order. And I'm not sure what a pretrial order is.
Okay. Are you willing, and certainly you do not have to take the stand and testify under oath. You have a right to remain silent. You have a right not to testify if you choose not to.
What would I be testifying to?
Whether or not you were aware, for this hearing, whether or not you were aware of the pretrial order.
I see. I'll do that.
All right. And counsel, I understand that you have a deposition scheduled after this.
Yes, Your Honor.
And so she is taking the stand for the limited purpose of the pretrial order in this case.
I understand.
All right. Ms. Bruni, if you would approach. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, have a seat. Counsel, I'm going to ask a few questions, and then you'll be entitled to cross-examine when I'm finished. Ms. Bruni, the court, I have called this hearing to ask you to show cause why you should not be sanctioned for not participating in the preparation of the pretrial order that was due on November 29th in this case.
I was not aware that I was supposed to prepare an order. I did get something from Mr. Bailey stating that I should show cause. There has just been so much harassment since all this started that it's document after document. And I simply wasn't aware that I should prepare an order, or even what the order is.
Counsel, if you'd like to cross-examine.
Please, the court. Ms. Bruni, did you know there was going to be a trial on Monday, December 5th?
No,
You did not know there was going to be a trial?
no,
Did Mr. Fletches, who entered an appearance in this case, tell you there was going to be a trial?
he was notified that Monday morning, I believe.
And did he tell you that there was a trial scheduled on Monday?
No,
Did you receive an email from me containing my correspondence to the court saying that you had not completed your portion of the pretrial order, and that had attached to that email my portion of the pretrial order? Do you remember that?
I do not. You hammered me with so many emails until I just don't remember.
And you read my emails, don't you?
Yes,
And you read my email about the notice of deposition today?
no.
Okay.
However, my computer has been down for a couple of days.
And but it's your testimony you did not receive the pretrial order from the court setting a trial date for December 5th. Is that correct?
I don't remember saying.
Okay. And so you don't remember whether, I don't know if I know how to follow up on it, don't remember, because the pretrial order did contain a date for the, for getting not the pretrial order, but I guess the scheduling order, I stated that wrong. And, did Mr. Fletcher, at any time ever tell you, Linda, we have a responsibility, you have a responsibility to get your portion of the pretrial order to Mr. Begley because you've got a trial on Monday, December 5th. Did he ever tell you that?
I don't believe he did, because that Monday he called, and I believe was in the courtroom at that time, the courthouse. And I did not know, I don't know how he was notified, but I did not know that there was supposed to be anything that day. I was surprised that he was in Canton because I didn't know about it.
I really don't have any further questions.
Ms. Bruni, you may step down.
Okay.
A few things that have already been made of record in this case. Mr. Begley filed in document number 35, which appears to have been an email, Mr. Begley, that you sent to Ms. Bruni on November 30th, explaining that you had been under the impression that she was represented, and because of ethics rules, you were corresponding with Mr. Fletcher instead of her directly. It appears from other pleadings that Mr. Fletcher finally responded to you on November 29th saying, I don't represent her. And I gather from this email that this was the first time he had responded to you based on the emails that you produced as far as and not informing you that you should have been talking to Ms. Bruni directly had you known that he was not representing her. Obviously, I can't answer for Mr. Fletcher why he didn't just respond to your, I assume there were previous attempts based on your email that he did not respond to. Certainly that's not the behavior that one would expect from a member of the bar. However, he's not here to defend himself, whether he got the emails or not. So, but as far as Ms. Bruni and whether or not she intentionally defied the pretrial order, I will note that as I was looking through this case, trying to get up to speed, the pretrial order that is filed by the court, that if you're on NEC, obviously, it goes to attorneys of record. And usually the clerk's office will send that type thing in regular mail to pro se defendants. However, on that pretrial order, there's nothing indicating in the file that it was sent via U.S. mail. I looked. And so the pretrial, the order to create the pretrial order, there's no proof in the file that it was sent to Ms. Bruni. There's nothing, obviously, Mr. Begley was not corresponding directly with Ms. Bruni because he wasn't supposed to, and he thought he was dealing with an attorney that represented Ms. Bruni, but in fact, he wasn't. And so I find that Ms. Bruni has shown cause that she did not know about the pretrial order and there could not participate in creating it. Now, as we move forward, today a deposition will take place. It will take place, I assume, Mr. Bailey, you're ready with the court reporter to go forward?
Yes, Your Honor. The circuit clerk gave us the library to do the deposition.
That's fine. The library is upstairs. There is an elevator. And if you need that, Ms. Bruni, don't know that you do, didn't mean to insult your ability to take the stairs. But the library is upstairs, and that deposition will continue. And if there are objections, that I will be here all afternoon objection, you have an issue, please feel free to contact me. Please be judicious in trying to draw me into it as far as objections. But you are, since you're dealing with pro se defendant, counsel, I'll trust you not to take advantage of that. You do your best, I know you will. And, but I will be in the courthouse if that's something that I need to attend to. I want to get this case set for trial, as I know you do. And so there probably needs to be some discovery done before we set a trial date. And Ms. Bruni, I know that today you filed a motion to dismiss. That will need to be heard after the plaintiff has an opportunity to respond and properly respond to that and set that for a hearing. But the deposition will go forward today because that was noticed in my order a while back. Any other questions?
No, Your Honor, I will try to not take advantage of a pro se defendant. I think it was discussed at one hearing back that the nature of the cause of action, which is a conversion, embezzlement tort, has got a criminal analog to it, and I believe we generally discussed the attention that needs to be paid, the rights of the defendant to testify or not testify in circumstances.
Do I need to address that now so that we don't have to reconvene in a few minutes?
Yes, and that might maybe absolve me slightly of overreaching.
I understand.
Yes.
Ms. Bruni, this court is ordering you to appear and participate in your deposition today. I think you've been on notice that that was going to happen. And do you intend to invoke your Fifth Amendment right against self-incrimination today?
No.
Okay. And you understand that you have the right to plead the Fifth Amendment, and you're choosing not to?
Yes, I'm choosing not to.
Okay. With that said, you understand that you will, that when asked questions in your deposition, you are saying that you intend to answer those questions.
Yes.
All right. Let me advise you that if at any time you change your mind about invoking your Fifth Amendment right, that it is your responsibility to inform Mr. Bagley that that is what you are doing. And at that point, both of you will then get word through the court reporter to contact me. I've looked at my court reporter here. I don't think you're doing the deposition, no. So if at any time you change your mind and choose to invoke your Fifth Amendment rights, you should do that out loud. And Mr. Bagley, if you will get someone to get my attention, we'll get that back on the record.
Yes, Your Honor.
Are there any other questions?
Well, also, out of respect for Ms. Bruni's pro se status, she has mentioned in her motion to dismiss certain bank records that are for an account in her name with State Bank and Trust. And in the proceedings, I have subpoenaed those and did a 30B6 deposition of the bank. And I intend to use some of those, but she raised some privacy concerns, and out of an abundance of caution, I will, not, do anything with the records outside of using them inside this deposition.
Why don't, until that issue has been brought before me, I'm going to order that the deposition transcript and any personal exhibits remain under, not to be shared with anyone outside of persons involved in the case, as far as attorneys and litigants, until we come back before me to issue any reason why they should be In other words, I don't want the deposition transcript made public or the exhibits there too, since they're bank records, until we have an opportunity to hear argument on that. Yes, ma'am?
I received a notice, well, actually, I didn't receive the notice because the clerk sent, the notice that he had subpoenaed my bank records to a wrong address. And
What
I just-
address is it, did the clerk send it to?
The address they sent it to is 3811 Old Canton Road.
Is that your address?
No,
What is your address?
4911 Old Canton Road.
Well, therein lies, maybe we have the clerk sending things when it does send things somewhere that you're not.
But it's my understanding that I had 10 days to object.
On the subpoena, yes, ma'am.
Right. And I never got notification. And that's why I'm asking that.
Those records are gonna be under seal. He may ask you about them as far, because that is something you would have had to produce anyway, if it's your bank account, in this case. But they are protected under seal and are not to be disclosed outside of the deposition.
And Your Honor, in connection with the subpoena, but I was looking at my Gmail account. I did notify her by email that I was going to take the 30B6 deposition of the bank, and it described the bank records. In fact, it described every individual check. But I think the court's ruling provides the protection to this defendant that she desires at this juncture.
Yes, sir. Those records are to be kept confidential and sealed in this case only. And I would caution both parties, as exhibits are filed with the court, there was an exhibit that was filed that contained social security numbers and dates of birth. Ms. Bruni, I think that may have been your exhibit when you filed the district attorney's investigative file. It contained information in that file that had social security numbers and dates of birth. And that information should have been redacted before it was filed electronically. Just for your, I think the clerk has taken care of that, but for your future information, be very careful what you file as an exhibit so that it doesn't have that kind of information for the public. Anything else?
No, Your Honor, thank you.
All right, I want to set a trial date, and I will wait till after the motion to dismiss that Ms. Bruni filed today is heard, and so counsel, if you want to respond to that, and we'll get it set for a hearing. How much time do you need to respond?
Within the rules, I said 10 or 14 days?
10 days.
Yes.
Why don't we set it for next month for a hearing? And that way we don't have to rely on anything in the mail. Ms. Bruni, what I'm doing on your motion to dismiss, we're going to set a date to have a hearing on that. All right?
May I?
Do I need to pass that one? March the 8th at 1 o'clock.
Okay. May I ask while we're being filmed today?
A request, and I'm sorry, I should have said that ahead of time, the media, members of the media asked permission to, and they followed the right protocol to ask if they could come and video. And I granted their request with a few stipulations as far as not filming any other of the hearings that were taking place today. But their request was specific to this hearing.
Surely they will not be filming the deposition.
No, ma'am, the deposition is to be held in the library, and media is not allowed in that.
Okay. Will you have a bailiff present?
No, ma'am, but they are really close. Counsel, are you intending to video your deposition?
I am intending to video deposition, Your Honor.
All right, you have instructions that it is to be kept under seal until such time as we can review that as well.
I'm so instructed, and I will convey that to all parties.
Your Honor,
Yes, ma'am.
I object to being filmed in a deposition.
Counsel, what is your response to that objection?
Rule 32 authorizes video depositions. They're frequently done. It would be the best evidence. We may be using that deposition at trial for various purposes, and I think it'll be an effective means for the plaintiff to present his case. And I do it frequently, particularly with the key witness, with the defendant.
Won't there be a recording in that deposition?
Yes, ma'am, and I'm going to pull the rule up. Videoing depositions is something that is done on a regular basis, and I'm looking at the rule to make sure that we don't just sometimes do things because we do them. So give me 1 minute, I'm going to look and see. Counsel, I probably didn't bring the rule book with you.
I read the rule. There's no express reference to video depositions. A number of the local rules of the circuit courts throughout Mississippi have some specific rules for videotape depositions. I actually looked at it too because I was conferring with a colleague, and he said, be sure and amend your deposition, say you're going to do it by videotaping. So I got up and looked, and it's not there. It's in the federal rule. I think it's been interpreted to mean that if by any other means, it would be inclusive of that. But it is commonplace, and is allowed. And is, like I said, I found it to be effective when you're dealing with with defendant's testimony in cases. But I think maybe the Fourth Circuit Court District has got a whole page of rules
About video deposition?
Yeah, I think so.
But not this circuit.
I didn't see it for this county. I don't think I saw it for this circuit. And there was another district too that had it. And
I'm going to split the baby on this one, Ms. Brody. I'm going to allow the video deposition to take place immediately after the deposition is concluded. I would like for the videotape to be given to the bailiff, and he will deliver it to safekeeping until we can figure out if there's some sort of authority I don't want to prohibit you from videoing, only to find out later that there was a right to do it. But I don't want to permit it, only to find out that Ms. Bruni's objection was enough to stop it. So I will allow a video today, but the video will be in my possession, the court's possession, until we have an answer to that question. And counsel, if you want to do any more homework than what you had time to do, then I would appreciate any authority either way.
I'll do that, Your Honor.
Okay. You understand, Ms. Bruni?
I do, and I would like to change my right to take the Fifth Amendment if I need to.
I can't assert whether or not you need to. Do you wish to
But
take?
will I be allowed to?
Do you want to take your video, counselor? I believe what Ms. Bruni is trying to say, that if you're going to video, she's going to assert her Fifth Amendment right.
I don't see how that, but I'm just taken aback here. I mean, because,
It's her right, she can assert it for whatever reason, but if I'm understanding what Ms. Bruni is saying, that is her intention. Her motives for taking that right are not this court's concern.
it's my desire to proceed with my trial strategy and to use a videotape deposition. So, and frankly, I was anticipating that that alternative may occur, not the video with no video, but her taking the Fifth Amendment. And I know the court has said you can't examine why she's doing this, but the difference between a video deposition and a type deposition is just, there shouldn't be a difference, particularly when the court has got custody of the video. I'm going to proceed with the deposition. She's got to do what she's got to do.
This entire thing is pure retaliation.
Ms. Bruni, do you understand my ruling on the video, that it will be held by the court, no copy will
I
be
do.
made, and that the video will not be released unless by order of this court? And even at that point, without pre-ruling why, the only reason for this court to use it would be in case of a trial where the video would need to be used. And so it is your right to assert the Fifth Amendment if you choose to do so. And this court does not want to persuade you one way or the other. I just want to make sure you understand my ruling on whether or not a video will be made. What do you wish to do?
I wish to use my Fifth Amendment right.
And not testify in light of the deposition.
Well, I'd rather not
You'd rather not what?
give a deposition.
Are you asserting your Fifth Amendment right?
Yes.
Counsel, do you have any argument as to whether or not it's a valid assertion of that Fifth Amendment right?
Well, I think it can be, given the particular questions I'm going to ask. And I'm going to ask about 38 checks that were written, and they are discrete acts. And they were, and they're alleged in the complaint that the defendant forged Mr. Allen's name and negotiated checks both in Madison and Hines counties, and for her personal use.
So you would agree that it's appropriate if she chooses to assert her Fifth Amendment?
Yes, and as I would contemplate the deposition proceeding, I mean, the assertion of the Fifth Amendment would be at least asserted on each specific criminal act, alleged criminal act that I'm going to ask about, which is a forged check there's also a scheme attached to that check where the monthly bank statement was fabricated to change the payee's name. So those are individual acts. But what I was hearing from the defendant and the court may have been asking me is whether there's a blanket Fifth Amendment assertion that completely prohibits the deposition from taking place. And admittedly, this type of situation doesn't come up very often in civil practice. But as I've seen it done, I think the assertion of the Fifth Amendment maybe is with each question that is asked, although I just had not thought of it in any other respect.
Yeah, I think she has indicated that she intends to take the Fifth Amendment in a blanket sort of way. We can ask, are there questions that you intend to answer some questions and then assert your Fifth Amendment right on other questions, Ms. Brenda?
Yes. When you take the fifth, does that indicate that you might be guilty? Is that the...
All I can tell you that Ms. Bruni, is that you have the constitutional right to plead the Fifth Amendment. As to what that does in the minds of people who may be sitting in the jury, I can certainly instruct them that they are not to make any inference of guilt based on that Fifth Amendment right, but they will know about it because this is a civil case, and the jury will know that you are refusing to answer because you're asserting your Fifth Amendment. I cannot answer whether or not what that will do in their individual minds.
Well, I'm tempted to
Would you like
answer.
a few minutes to think about it?
No, this entire scenario is started about 6 months after I was fired from downtown Jackson Park.
I understand. Ms. Bruni, I'm going to stop you because I understand where we are, how we got here, and your pleadings have made very clear your feelings about the process. But right now, we just are talking about whether or not you're going to plead the Fifth in your deposition. You have said you are going to plead the Fifth. My question is whether or not you intend to plead the Fifth on every question.
Yes.
Okay. In that case, then I see no reason for a deposition to go forward. Counselor, if you would like to preserve that deposition and let her assert her Fifth Amendment on the record in your deposition, then that will go forward. I see no reason to go through every question if she's saying now that she intends to plead the Fifth on every question. Response?
I'm trying to absorb this.
It's a first for me too.
And maybe we should recess for about 5 minutes, but I mean, the deposition can be used for any purpose in these civil proceedings that are authorized under the rules of evidence. And so, we've got scenarios. I mean, even to preserve the record, I believe I'm going to need to ask her questions, and she needs to just take the Fifth
On each question.
On each question, and and that may I may be able to abbreviate the deposition some, but surely I would not want a situation where we don't have a deposition. She shows up in court in her defense and starts testifying, and then.
I understand.
Yeah, and I feel like we've got, I need to at least have a prior inconsistent statement.
My concern is this: when in a law enforcement situation, when someone pleads the Fifth, Mr. Bailey, if you might can help me on this, at that point the interrogation stops. what I don't want to happen is for questions to keep coming and in essence wear down Ms. Bruni to a point where she waives her right unintentionally because of just exhaustion or feeling coerced into testifying when she, out of frustration, when she has already pleaded the fifth and has indicated her intent. But I don't want to prevent you from making a record that she is going to plead the fifth. And so,
Understood. And this case, I mean, it has a global significance, but very specifically, there are 38 checks
I understand.
that we allege. And so, but I respect the court not wanting to wear this witness down with a very taxing question. I mean, you know, it's existential, it's elemental. So, I almost wish a public defender were in the room right now. And so, I know it's a civil court, but
It would be nice to have a pro se public defender, would it not? Let's take a 10-minute recess, and I may stay right here on my computer and do a little research. We'll cut the cameras off during the break, and we'll recess. So if y'all want to step out just a minute, and be able to bring it back in.
okay.
Okay. Well, I guess that solves our issues for now. During the recess, I did take a look at some authority, and counsel, you have every right to take a video deposition, just so that we're on board with everybody understands. Wanted to find authority. You do have the right to take that video deposition. I still want it to be kept in the court's possession for a little while until both sides have an opportunity to research that. Because certainly what I found was just a quick reference. Yes, you do have permission to do that. All right, given that you are not asserting the fifth, and let me just say to you, Ms. Bruni, the video will take place in the library, and if at any time you decide to assert your Fifth Amendment, you do so, but counsel will be able to continue asking questions, and you will have to assert that Fifth Amendment privilege to each and every question as you see fit. I know you've been warned, or warned's probably the wrong word, I know you have been cautioned or advised by previous courts probably that you it would be in your best interest to have an attorney, but certainly at this point you've made the choice, the determination to go forward and represent yourself, which you have the right to do. Counsel, I trust you will do your very best to navigate through this without taking advantage of that status. I trust you will.
I will, Your Honor. I've got a duty under the rules about the unlicensed practice of law to make sure that Ms. Reeves, who is with the defendant, is not conferring with her during the deposition. And I don't want to create any disruption there, but normally the opponent can't turn to his lawyer or his or her lawyer anyway. So I think, but I don't want the deposition to get in an argument with them about what Ms. Reeves should and should not be doing.
I understand. Ms. Bruni, let me just explain to you, since you are representing yourself, if at any time you believe he has asked a question that you have an objection to, that you and you alone can voice that objection. And I understand that you're Ms. Reeves? Ms. Reeves is, your friend is here as a friend and someone to give you support and encouragement, but she is not a lawyer. And typically in a deposition, lawyers are not permitted to have side conversations with the person who's being deposed. And so any conversation that you would have with Ms. Reeves would need to take place during breaks. And if you need a break during the deposition, I'm sure that Mr. Bagley will accommodate that as long as y'all are making progress. The courthouse closes at 5 o'clock and it is now almost 3 o'clock. And so I will let y'all be on your way, and if an issue comes up, you know how to find me. All right, you're dismissed. Good luck.
Many times, personal attacks on me, and they come nowhere but from Mr. Bagley directly to young teenagers. And I would ask that it be prohibited, anything about this deposition, because they like to post the actual documents.
As of right now, the deposition is going to be under seal. I've already ordered that, and as long as the video and any transcript, it's under seal. And so the actual deposition will not be part of the public consumption. However, I can't issue any sort of order preventing the press or blogs from talking about the case. We have a freedom of press in this country. All right.
Good.
We're dismissed.
Thank you.